Good afternoon to you. Today we will continue with CCA CCA Rules 1965 for the section officers, private secretaries, for all participating and non-participating agencies like IB, AFSQ, Ministry of External Affairs, etc. and CSS, of course. In the last class we have seen the constitutional provisions governing CCA CCA rules. Today we will continue with other provisions of the rules. We have seen Article 309, 310, 311 and 320 in the last class. Today we will continue with other rules. First let us see what is the purpose of the CCA CCA rules. What is the purpose? The purpose is there are three purposes, explicit purposes three. What are those? Number one, classification of posts and grades. Number one. Number two, to prescribe penalty and procedure thereof to be followed in consonance with Article 311. Second purpose. Third purpose, the procedure to be followed in disposal of appeal, revision petition and review petition. These are the three express purposes of CCA CCA Rules 1965. So, if there is a question, this is the answer. Next is, what are the powers of the President? What are the powers of the President? Number one, to impose any of the penalties given in Rule 11. Number two, to empower any authority other than the appointing authority to impose such penalties on any official. Second purpose, that is the powers of the President. Third, to institute disciplinary proceedings or direct the disciplinary authority to institute disciplinary proceedings against a government servant. This is the third power. Fourth is to order common disciplinary proceedings. Fifth is to decide dispensation of the inquiry in the interest of security of state. Number 6 is to consider and dispose of appeal, revision and review petitions. Number 7 is very important, to exclude any class of persons from the operation of these rules. Number 8 is to remove any doubt which has arisen in the rules and also as to the interpretation of the rules and to exclude the person, which person this will not apply. This is the powers of the President. Now we are coming to whom these CCA CCA rules do not apply. Very important. Remember, that if you exclude these categories, the rest of the categories it applies. So this is the elimination process. To whom CCA CCA rules do not apply. Number 1, All India Service. Number 2, Railways employees. Number 3, Casual staff. Number 4, those subject to discharge from service on less than 1 month notice. Number 5, those excluded by special orders of President of India. Number 6, persons governed by special law. In addition to these 6 categories, government has excluded certain categories of staff from the operation of these rules. What are those? Under PNT, that is Post and Telegraph Department, that is Department of Post and Department of Telecom. Number 1, extra departmental agents. Number 2, monthly rated staff paid from contingencies. Number 3, monthly rated work charged staff and other employees not on regular establishment. Number 4, daily rated staff paid by day, week and month. Number 5, non-departmental telephone operators. Remember, these categories of staff have been excluded. They belong to PNT, Department of Post and Department of Telecom. Then, under MHA, Under MHA, police officers up to the rank of Inspector Police in CBI, that is Delhi Special Police Establishment, they have been excluded. Under Ministry of External Affairs, locally recruited staff in the missions abroad, excluded. Under Ministry of Urban Development, garden establishment and estate office of presidential estate, presidential secretariat, it has been excluded. Then under Ministry of Tourism, locally recruited staff in the tourist offices abroad and work charged staff of Mangalore and Tuticorin projects have been excluded. So remember, these are all excluded categories and important. If there can be easily a question, they will include some people who are included and they will ask you to eliminate. So important, you should remember, at least popular things you should remember. Next is, we have already seen under definition appointing authority. Now we will see who is appellate authority. Kindly remember, kindly understand, kindly follow closely. Who is appellate authority? You should not rely on anybody. You should understand yourself and need not go through the even books also. If you remember this, that is enough. Who is appellate authority? See, appellate authority has been given in the appendix attached to CCA CCA Rules 1965. So, first category, those authorities given in the schedule attached to CCA CCA Rules 1965 or those who have been specifically given under the special orders or general orders made by the President. Supposing if no such orders have been issued, then you should follow the principle. Follow the principle. What is the principle? Very simple. For Group A and B officers, for Group A and Group B officers, appointing authority is the appellate authority. If the punishment order was issued by an authority subordinate to it, remember again I repeat, for Group A and B, appointing authority is the appellate authority if the punishment order was issued by any authority who is subordinate to it. So it means appointing authority. Otherwise, President of India. Otherwise, President of India. Then for Group C and D, the authority to whom the punishing authority is immediately subordinate. That is, the authority to whom punishing authority is immediately subordinate. That authority is the appellate authority. Remember? Then, who is the disciplinary authority? Who is the disciplinary authority? Disciplinary authority is that authority who is competent to impose any of the penalties mentioned in Rule 11 of CCA CCA Rules 1965. Again I repeat, disciplinary authority is that authority who is competent to impose any of the penalties mentioned in Rule 11 of CCA CCA Rules. So remember, we will come to this at a later point. Even at this stage, you should remember, all appointing authorities are disciplinary authorities, but all disciplinary authorities are not appointing authorities. Because appointing authority can impose the maximum penalty of dismissal, whereas disciplinary authority cannot impose all penalties. Some disciplinary authority is competent to impose only censure. He is also called a disciplinary authority. If he is competent to impose only one penalty, namely the censure, he is called a disciplinary authority. Whereas appointing authority is the highest authority. As I have already told you, 4 types I have already told you. I have given the definition for appointing authority. Now, one exception is there for the appellate authority. What is that? The government servant can, however, prefer an appeal directly to the President against an order imposing on him any penalty by any authority other than President, if such penalty was imposed in respect of any activity connected with his work as office bearer or of staff association or union. In connection with the union work. Suppose let us say I am the office bearer of a JCM or staff association And because I was involved in official work, attending a union meeting, etc., I have been targeted by the department. In that case, I have the right to prefer an appeal directly to the appointing authority, provided it is not the president. If the president has issued an order, remember, wherever I say president, it is the minister in charge. Because under article, I have already told you under the constitution class, kindly go through the constitution class under article 53 and 73, 74, 75, all powers are exercised by the president only on the advice of the prime minister, the council of ministers. And the only choice open to the president is to refer back any advice. If the advice is reconsidered and tendered again by the council of ministers, president is bound to act in accordance with the reconsidered advice. In nutshell, president cannot act without the advice of the council of ministers, nor can he act contrary to the advice of council of ministers. So wherever it is the president, the nominee is the minister in charge. Kindly remember this very important point. Secondly, we are coming to the most important rule, suspension. What is the rule number 10? So we have now seen how do you distinguish between CCA CCA rules and CCS conduct rules. Then we have seen what are the powers of the president. We have seen to whom the CCA CCA rules does not apply. We have seen what is the purpose of the CCA CCA rules, and we have seen what is the definition of appointing authority. We have seen what is the definition of disciplinary authority. We have seen what is the definition of appellate authority. All these things we have seen. Now, rule 10, suspension. Remember, what is suspension? Suspension is nothing but an executive action. Every word is important. Remember, you should never forget. Suspension is nothing but an executive action against a government servant for the acts of his misconduct, misdemeanor, or delinquency, to keep him away from office for temporary period pending final action in the disciplinary proceedings to which he has been exposed. Very simple. That is, suspension is an executive action against a government servant to keep him away from duty for the act of misconduct for a temporary period pending final action on the disciplinary proceedings initiated against him. Very simple. This is suspension. Remember, suspension is not a penalty. It is already even Supreme Court has declared. Suspension is not a penalty, but nevertheless, it is a social stigma. In spite of the fact that it gives you half of the salary, half of the leave salary, it is as bad or as good as a half pay leave. In spite of it, for no work you are getting half pay. In spite of it, no one wants to be placed under suspension. Why? It is a social stigma. The moment you are said that I am under suspension, people will look you down. You will be looked down contemptuously by the society. And for everybody, right from the peon to the prime minister, every individual has his own ego, his own dignity, his own esteem. So nobody wants to get affected that ego, that esteem, that self-respect. So nobody wants himself to be suspended, irrespective of the fact you get full salary or half salary. So suspension is not a penalty, penalty no doubt, but it is a social stigma. Remember. Second point, who can suspend? Who can suspend? 4 authorities can suspend. Who are all they? Number 1, appointing authority, or any authority to which it is subordinate. It means appointing authority. Again I repeat, appointing authority. Secondly, or any authority to which it is subordinate, or disciplinary authority, or number 4, any other authority who is specially empowered in this behalf by general or special order made by the President of India. So 4 authorities can suspend. One is appointing authority, or any authority to which it is subordinate, or the disciplinary authority, or any other authority who is specially empowered in its behalf by general or special order made by the President of India. So 4 authorities. Then, what are the circumstances? What are the circumstances? Remember, circumstances are statutory, not guidelines. There are 2 things. One is which is given in the rules, and the other is guidelines by the CVC. Now I am giving you the statutory circumstances and it has to be obeyed. What are those? Number one, where a disciplinary proceeding against the government servant is contemplated or pending. Is contemplated or pending. Contemplated means proposed. Pending means already issued. See, suppose let us say I have claimed my LTC, forged bill, and I have shown from Delhi to Thiruvananthapuram by flight. On that day there is no flight. So there is a prima facie, it is established, I have furnished a fabricated bill. But they have not, no charge sheet has been issued. Suspension can be resorted to because there is a prima facie case. So, number one, where a disciplinary proceeding against him is contemplated or pending. In this case, no charge sheet has been issued. But on the basis of preliminary inquiry, the disciplinary authority has come to the conclusion that there is a prima facie case existing. In other words, framing of definite charges and communication of such charges is not a precondition for suspension. Remember, this is number one. Number two, where the competent authority is satisfied that the government servant has engaged himself in activities which are prejudicial to the interest of security of state. To the interest of security of state. Too clear to elaborate. Very clear. It is crystal clear. There is no need for any elaboration. If he is involved in espionage or any activities which are prejudicial to the interest of the security of the state, he can be straight away suspended. Second point. Third point, where a case against him in respect of any criminal offence is under investigation, inquiry or trial. What is that? Again I repeat, where a case against him in respect of any criminal offence is under investigation, inquiry or trial. So remember, a government servant against whom the proceedings have been initiated on a criminal charge, even though he is not detained in custody. Even though he is not detained in custody, suppose he is on bail, even in this case also, you can place the government servant under suspension. In fact, if the charge is connected with official position, or moral turpitude, he should be placed under suspension unless there are stronger reasons which should be recorded in writing for acting on the contrary. That is, if you do not decide to place him under suspension, the reason should be given. When the charges are related to moral turpitude or related to the official position. Let us say he is a cooperative society secretary or treasurer, he has mishandled the cash. Cooperative society is not under us, so you cannot say it is affecting the moral turpitude. So if it is affecting the moral turpitude, you have to place him under suspension. Remember. Second, another condition is, if the order of suspension has been made by any authority lower than the appointing authority, such authority should forthwith report to the appointing authority the circumstances under which the government servant was suspended. What is, suppose Mr. A, the appointing authority is joint secretary, but A was suspended by suspension, disciplinary authority can do. So remember, it is not appointing authorities. Who are all the four authorities? Appointing authority or any authority to which it is subordinate, or the disciplinary authority or any other authority who is specially empowered in behalf by general or special order made by the President of India. These four authorities can suspend. So, if a disciplinary authority who is subordinate to the appointing authority has suspended, it is his duty to intimate to the appointing authority the circumstances under which that fellow was suspended, because the appointing authority has every right to know about a person for whom he is appointing authority, why this fellow was suspended. Remember, that is very important. Of course, such a report is not necessary in the case of suspension made by CAG with regard to a member of Indian Audit and Account Service. He is subordinate to President. That is not necessary. He is a CAG need not give any report to the President. So, subject to this, we have completed up to Rule 10. We will continue in the next class. Thank you.